So good evening, everyone, and welcome to this LILA webinar, which is our first ever webinar, and hopefully will go smoothly as possible in the circumstances. My name's Gráinne, Mellon. I'm the chair of LILA, and we're delighted to have you all with us this evening and to have such a great panel to discuss this seminar on the Good Friday Agreement and the rule of law. Just quickly, in terms of some housekeeping, we have a really high number of attendees this evening, which is brilliant. But please do turn off your cameras, as I can see many of you have done, just because it's going to help us in terms of making sure there's no interruptions to the webinar. And you're also all on mute, but we hope that you can still participate by asking any questions that you have in the chat function, which is, as you'll all know by now, after months of COVID-19 Zoom seminars, is down at the bottom of your screen. And please do ask any questions as you go along, and I will try to ask as many of them as I can at the end of our presentations. But very briefly, we are here this evening to discuss primarily the Internal Markets Bill, which obviously passed through the Commons last night. And it's hard to imagine a more relevant discussion for us as London Irish lawyers. Obviously, the bill has raised very serious concerns amongst the legal community about the rule of law, and in particular clauses 43 to 45 of the bill, as we'll come to hear, gives the government a preemptive power to infringe the Northern Ireland Protocol, which of course is a crucial component of the withdrawal agreement, which is, of course, a treaty that this government signed months ago. But in addition to those rule of law issues, which have triggered resignations and comments from the Lord Chief Justice of Northern Ireland, as well as very strong statements from the Bar Council and the Law Society, there is an additional component which is of interest, no doubt, to all of us. And that is the way in which the Good Friday Agreement is being used as an apparent justification for this piece of legislation and the powers contained within it. What can we make of that, and what does it mean for the Good Friday Agreement, as well as for the rule of law more generally? So here to answer all of these questions is our very distinguished panel, and we're really delighted that they were able to be with us, especially at such short notice. And we're going to hear from each of them, and then there'll be an opportunity to ask any specific questions at the end. So first of all, we're delighted to have Colm with us, who is a professor of constitutional and human rights law at UCL. Colm is a graduate of UCC, the University of Edinburgh, and King's Inns in Dublin. He was called to the Irish Bar and has worked as a legal advisor in the UK House of Lords and as a specialist legal advisor to the Joint Committee on Human Rights. And I suspect he may be glad he no longer has that specific responsibility at the moment, but I could be wrong. And we're also delighted to have with us Gallagher, who is a QC at Doughty Street Chambers, again, specialising in human rights and civil liberties. Caoilfhionn is from Dublin. She's a graduate of UCD and the King's Inns and practiced in Dublin before moving to London. She's been involved in many of the major human rights cases in recent years, and I'm not able to quote all of the awards that she has received. They include UCD Alumni Awards and being named by the Irish Times as one of the most 100 influential Irish women outside of the country. So Caoilfhionn is a long-standing friend and supporter of LILA. We're delighted to have her with us this evening. And last but not least, we have with us Emma DeSouza, who is from County Derry and is a campaigner on the issue of citizens' rights. Many of you will know the case that Emma brought against the Home Office, which settled recently at the door of the Court of Appeal, in which she argued that her husband, who is an American citizen, should be able to join her to live in Northern Ireland by reference to her EU law rights as an Irish citizen, and not by reference to her British citizenship, which of course is ascribed to her, but not one that she identifies with. In bringing that litigation, she relied on the Good Friday Agreement, and in particular the provisions which enable anyone in Northern Ireland to identify as Irish or British or both. As a result of Emma's litigation, there now is a completely, quite remarkably, separate legal framework for what is defined a relevant person of Northern Ireland. And if you are that person and need some immigration advice, act quickly, because it's in force, I think, until June of next year. Emma has since that case continued to campaign around the interpretation and implementation of the Good Friday Agreement, and she is also the vice chair for votingrights.ie. So I'm sure you'll agree we have a brilliant panel this evening, and I'm going to hand over first of all to Colm for his thoughts on this bill.
Great, Gráinne, thank you very, very much, and thank you for hosting us. Let me begin with an apology. I've been recovering from a cough that required a COVID test last week, and I've had 2 full days of online teaching, our new world of university law teaching. So my throat is a little bit rough, but hopefully I'll get through this. It's not the only thing that's rough, I have to say, because of course we've entered a rather bizarre period at the moment where the UK government is legislating in flagrant violation of a treaty commitment and triggering all sorts of rather interesting and complex constitutional questions. What I'm going to do over the next 10 minutes is to give you the legal background, to go through the boring technical legal detail of what's happening and why it's happening and the issues it generates. And then Caoilfhionn and them are going to do the really interesting bits of getting down to the brass tacks of what's going on beneath all of this. So that's what I'm going to set out to do anyway. Okay, so what's going on? We have this internal market bill, which has just yesterday passed its 3rd reading in the House of Commons. Now, for those of us with an interest in the constitutional machinations of the UK, the internal market bill has been an interesting thing waiting to happen for quite a substantial period of time, because it has all sorts of interesting constitutional implications internally within the UK. As I say here in my first bullet point on what hopefully you should all be seeing, the UK Internal Market Bill is inherently controversial because of its impact on existing devolved competencies. Effectively, the Westminster government, through the bill, is taking the power to regulate for market integration within the UK, for a single UK integrated market. This has all sorts of interesting legal implications as regards Scotland. So, for example, the bill in its current form would give UK ministers the power to effectively override Scottish alcohol minimum pricing legislation to ensure that English alcohol producers were able to compete on a level playing field with Scottish alcohol producers. So there's an interesting set of constitutional issues there with, for example, the Scottish National Party and the Scottish government accusing Westminster of clawing back powers that the devolved settlement had originally given to Edinburgh. I'm just mentioning that in passing before moving on to the meat and drink of the issue that's gone ahead. What we have in the current bill are 3 key clauses. I see from the chat that some of you at least aren't seeing the paper. Don't worry, we'll share the notes afterwards. There's 3 key clauses in the internal market bill that are the problem, and they are new clauses. They weren't expected. They were introduced word began to spread that they were coming around 3 weeks ago. Their introduction has generated this mini constitutional crisis that we're seeing unfolding at present. In essence, clause 42 enables ministers to make regulations overriding the provisions of the Northern Ireland Protocol in relation to customs exit declarations on goods moving between Northern Ireland and Great Britain. Clause 43 enables ministers to override the protocol's requirements in respect of state aid provisions. And clause 45, which is the real meat and drink of the matter, clause 45 effectively knocks out the direct overriding effect that had been given to the Northern Ireland Protocol and the withdrawal agreement over competing UK law. It effectively disapplies the Withdrawal Act and the withdrawal agreement and the protocol, and allows ministerial regulations to trump the Withdrawal Act and the protocol. In particular, and this is the technical legal point, it provides that not alone can the regulations trump the protocol, it also reverses the standard presumption that the courts apply in interpreting legislation. The standard presumption being you interpret legislation subject to the presumption that the UK intended to comply with its international treaty obligations, in this case, the Northern Ireland Protocol and the Withdrawal Agreement. That presumption is knocked out by the provisions of Clause 45. But Clause 45 goes even further and actually effectively turns into a partial ouster clause. It effectively forecloses judicial review, many aspects of judicial review, many potential judicial review avenues of challenge to the regulations being introduced under clauses 42 and 43. In particular, for example, it restricts the application of the Human Rights Act. You can, as the bill currently stands, you will be able to look for a declaration of incompatibility, but will not be able to get a strike down of ministerial regulations under Section 6 of the Human Rights Act, because Clause 45 classifies these regulations as primary legislation. Now, there's a lot going on there. What is the impact of these legal provisions? First of all, we have a clear breach of the requirements of the withdrawal agreement and in particular the Northern Ireland Protocol. What's so fascinating about the politics of this is that the UK government were quite happy to announce the clear breach of a treaty commitment in the House of Commons, with Brandon Lewis, Secretary of State for Northern Ireland, saying, yes, this does break international law in a very specific and limited way, a phrase which we've all heard an awful lot about over the last 2 weeks. Bonus marks for honesty, not much marks for much else. The notion of a very specific and limited breach of law is a rather interesting concept. But it's a straightforward admission that the withdrawal agreement and protocol are breached by the provisions of Clause 45 in particular. The other clauses are set up a potential future breach. Clause 45 runs directly counter to the requirements of the withdrawal agreement. So there's little or no debate. No one has seriously proposed that the Internal Market Bill, as currently worded, does anything but drive a coach and horses to the provisions of an international treaty. There are other issues. There is an argument ongoing as to whether this breaches the ministerial code. And it's a rather complicated matter. I'm not going to go into detail. We can discuss it further in questions. The answer is maybe, maybe not. The overall significance of that is perhaps not massive. More importantly, as Professor Mark Elliott in Cambridge has repeatedly pointed out, there's actually an issue of domestic constitutional principle here, because Clause 45 is in effect as I said, a partial ouster clause. It could be viewed as a very, very significant restriction on the ability on judicial review and the ability to seek remedy before the courts over something that could be quite far-reaching, in particular the potential impact on state aid. And then, of course, there is the indirect impact on the Good Friday Agreement, because, of course, any undermining of the Northern Ireland Protocol could call into question the open border that the protocol was designed to guarantee, leading, of course, to the knock-on consequences of undermining key provisions of the Good Friday Agreement, in particular Strand 2, the North-South Republic of Ireland, Northern Ireland dimension. Is all of this justified? We can discuss this further, whether all of this is justified. How would I put it? The best vaguely plausible set of arguments I saw put forward about this by John Finnis and John Larkin QCs. John Larkin, as many of you will know, having been Attorney General for Northern Ireland until quite recently. They set out in The Spectator this rather detailed set of arguments that there isn't really a breach of law, because yes, there's a breach of an international treaty, but it's not a Jus Cogens breach. It's not a breach of some massive overarching principle of international law. And in any case, the UK Parliament can legislate as it sees fit, and ministers can always suggest to Parliament that they enact legislation in a particular way. So they try effectively to soft soap what's going on by saying, look, it's only a minor breach of the international rule of law, and Parliament can do what it likes. The Attorney General before Parliament tried to make a similar argument where she said, to quote, it's proper, it's constitutional, and it's lawful. And she ran those three concepts together: proper, constitutional, and lawful. It's as a matter of UK law, it's certainly lawful for Parliament to legislate as it sees fit. Whether it's proper for the government to invite Parliament to legislate against an international treaty, and whether it's constitutional for a government to behave with such overt disregard of a treaty commitment and international rule of law is another question. It's worthwhile bearing in mind in all of this that actually there is a dispute resolution process built within the framework of the protocol, and that Article 16 of the protocol does make provision for the UK to disapply provisions of the protocol if it gives rise to sort of fundamental economic or constitutional issues. But all of this stuff is supposed to be handled by the internal dispute resolution mechanisms within the protocol itself. So what's actually going on is that there isn't even an attempt to dress up the breach of the protocol. There is a clear and direct overt breach of the protocol, a breach of a treaty commitment solemnly entered into with the EU last November, with Ireland and other EU member states moving their position in good faith reliance upon the treaty. And it's a breach that isn't camouflaged, that isn't dressed up, unlike, say, the Iraq War in a set of justifications. We have an overt, admitted treaty breach, which also gives rise to certain very, very troubling issues from a domestic constitutional point of view, and indirectly has a potential knock-on effect on the Good Friday Agreement. And of course, at the end of the day, just to compound the problem, also, of course, obviously enhances the possibility of a no-deal outcome to the current trade talks. What can be done about it? I know Keelan's going to discuss this in a little while. The European Commission is looking into the possibility of taking enforcement action against the breach before the Court of Justice of the EU. It's certainly been raised as an issue already in the joint committee that's been effectively the arbitration mechanism for handling disputes under the protocol. The Commission's response will, at the end of the day, be dictated by the politics of the situation. For all of us who are sort of lawyers operating in the UK, the wider considerations are troubling, putting it mildly. And it's been interesting to see, and I'll conclude on this point, how you've had intense controversy in legal circles, with the Advocate General for Scotland, Lord Keane, resigning on a point of principle, sharp opposition from, for example, Theresa May and John Howard to the proposals, a strong possibility that the House of Lords will block the bill going forward. But none of this intense legal controversy has necessarily been reflected in, for example, BBC News coverage, and it hasn't been reflected in any sort of substantial rebellion in government ranks in the House of Commons. So we're in, frankly, troubling constitutional waters for the UK, which obviously has a clear impact on the Good Friday Agreement and UK-EU-Irish relations going forward. So that's the general background. Apologies to those of you who knew all that already, but I hope it sort of gives an overview of the complex network of issues that's going on here. Okay, thank you.
Thank you, Colm, and we will take any questions that arise from that. Again, just a reminder, if you do have a question, please feel free to put it in the chat and we can come back to it when we've heard from all three of our speakers. But thank you, Colm. And I think next we're going to hear from Emma, who obviously has a direct personal experience of bringing a case against this government in which arguments were made about the Good Friday Agreement. And so we're going to hear from her about her case and about any parallels that arise in relation to this bill. Thank you, Emma.
Thank you so much, Gráinne, for having me. And thank you, Colm, for that stark summary of where we find ourselves in at the moment. It has been quite extraordinary to hear the government and officials cite protecting the Good Friday Agreement as a reason for potentially breaching and breaking international law. The very fact that our hard fought for peace is inherently grounded in the foundation of international law does seem to have been lost on some of them. To be clear, of course, the Northern Ireland Protocol protects the Good Friday Agreement. And in my view, the use of the peace process to justify any breach of international law is all but sloganeering. There's no substance of any kind to that claim that's being put forward. The European Commission considers this to be a unilateral move that is illegal and does not accept the argument that the aim of the Internal Market Bill is to protect the Good Friday Agreement, but actually stated that it is their view that it does the opposite. The majority of Northern Ireland's political parties do not support the government's actions or accept their argument that is to protect the Good Friday Agreement. In fact, the only Northern Ireland party to support the government's position in this has been the DUP, who openly campaigned against and opposed the Good Friday Agreement. Some may be familiar with their case, and so I hope I don't bore you all to death with the details while I try to cram a 5-year legal challenge into a few short minutes, but I will hopefully be able to do that. Our case concerned the principles as laid out in the Good Friday Agreement and access to EU rights and entitlements. It spanned over 5 years and raised concern over the government's commitment to the agreement and whether the citizens can really rely on our truths the most. So, identity in Northern Ireland is particularly complex. The Good Friday Agreement dealt with the question of identity and citizenship under Article 1.6 of both the Multi-Party Agreement and British-Irish Agreement. The British-Irish Agreement is an international treaty between the Irish and British governments registered at the UN, and Article 1.6 is commonly referred to as the birthright provision or birthright protection. It concerned itself with ensuring that no one identity or community would be held above the other in Northern Ireland and sought to protect identity so as to remove it as a point of contention, which it was for a very long time. Our case began in 2015 when the Home Office, under the remit of the 2012 McCarthy decision,
I think we may have lost Emma temporarily, but we'll just give her a minute or two to see if she can join us. Such are the risks of a Zoom event like this. We'll give her just a minute or two. Okay, I think we've lost Emma, so we'll wait for her to come back in, and just as we do, Colm, I might ask a couple of quick follow-up questions from your presentation, if you don't mind, just while we're waiting. You mentioned that this wasn't a dressed-up breach, in that it was on the face of the legislation, so that it's a preemptive sort of proposed breach. Are you able to give us your view on why you think the government have introduced this in this way, or whether in fact that matters in terms of the rule of law?
I think it's quite clear they're looking for a fight. I think it's quite clear it's a deliberate confrontational strategy as part of their negotiation strategy with the EU. If they really were concerned about the trade flows, and there's no doubt that there's some policy concerns there. As I said, there's a mechanism within the protocol to deal with it. And in fact, the government expressly said they were concerned about a food blockade in the EU refusing to certify food imports from Northern Ireland going to GB. And that's what the Prime Minister said this was all about. But as Ed Miliband repeatedly pointed out in the House of Commons, nothing in the bill touches that particular issue at all. That's all left to be dealt with by the dispute resolution mechanisms in the protocol. So in other words, the government's stated key justifications for this measure aren't reflected in the actual text of the bill itself. So that suggests that the main motivation for this may be an attempt to raise the stakes in negotiations with the EU. And whether that's a smart strategy, even setting aside the collateral damage to rule of law, is an open question, putting it mildly.
And in terms of next steps, obviously, there's been various hints that, particularly if it's primarily politically motivated, that this bill won't in fact ever see the Lords. Is that something you think is likely, or do you think it's likely to be stalled now or even withdrawn?
The bill will go through because the government is already, it's a really interesting and problematic bill in all sorts of other ways. So the bill is going to go through. The question is, will these clauses be deleted? The government has sort of suggested if a deal is done that suits them, those clauses will be deleted. But there's also been noises coming from the government that they've no intention of deleting the clauses, that they make a clear statement that if the protocol mechanism isn't working, parliamentary sovereignty will be used to override it. And there are voices in the government saying that quite expressly, which calls into question the entire integrity of the protocol.
Hello?
Oh.
Hi there, Emma. Welcome back. We'll just hear for you, Emma, in one moment. We're just finishing a quick question for Colm, and we'll give you a minute and then we'll come back to you if that's okay. Just one further issue you mentioned, obviously.
Can anyone hear me?
Hi, Emma, we can hear you. If you just give us a minute. Colm, I wanted to ask you about the likelihood of this getting to the Court of Justice, both in terms of jurisdiction, depending on the date of the breach, and then obviously the political likelihood of that being the route that's taken.
Yeah, there's EU international law academic scholars are fairly unified that are unified in agreement there's a breach of the good faith provisions.
Guys, I can't believe it, but would you believe the internet? Thank you.
Want me to go on?
We'll come back to Emma in a minute. So Colm, yes, do go ahead.
Okay, yeah. So the general consensus seems to be that the Commission could bring a legal action now before the Court of Justice of the EU, and could certainly and have already initiated discussions in the joint in the joint commission that's supposed to be the arbitration mechanism for the protocol. Whether the Commission politically, whether it makes sense for the Commission politically to trigger enforcement action in the Court of Justice, given the potential for that to actually escalate politically, is another question. Any damage awards, for example, from the Court of Justice would then raise an issue of whether the UK government / parliamentary majority would accept those damage awards. There's all sorts of messy issues here. So the Commission, I suspect, are going to be very slow before triggering legal enforcement action on this.
Thank you, Colm. That's great. And Emma, I think we have you back again now, hopefully. Can you hear us? No. We have Emma in spirit, but not in...
Yes, I am.
Emma, feel free to turn off your camera if it helps.
I think I'm here now. Can you hear me?
Yes, we can.
Let's see. Okay, I'm going to turn off the camera. Can you hear me now? Is that better?
That's great, Emma. Yeah, if you can hear us, feel free.
Are we good to go?
We're good to go.
Okay, thank you. And apologies, of course, my internet provider just cut off and is doing maintenance in the middle of this webinar. I tell you, throughout lockdown, I have been cursed with technological problems. So of course this would happen. But let me try to continue with where I was, and hopefully we can get through this without any more hiccups. So I was at the point where I was discussing how the Home Office ignored the stark differences between McCarthy, a British citizen born and residing in England, who obtained Irish citizenship solely by descent, and a person of Northern Ireland who, under the terms of the Good Friday Agreement, has an explicit right to be accepted as Irish or British or both. Instead of addressing the incompatibility of domestic UK immigration law with commitments to the Good Friday Agreement, the department fought the case through the immigration tribunals, enlisting one of the most experienced and advanced constitutional lawyers to do so. We had success in 2017 when Judge Gillespie, who presided over the first tier tribunal, ruled in our favour, citing the constitutional nature of the Good Friday Agreement. He stated that the people of Northern Ireland are permitted to choose their nationality as a birthright, therefore nationality cannot be imposed upon them at birth. The Home Office lodged an appeal against the first tier tribunal decision, which was initially refused. A second appeal was lodged to the upper tribunal and subsequently granted to the Home Office in May 2018. However, the case wasn't heard by the upper tribunal until September 2019, due to 2 consecutive adjournments requested by the Home Office. During the court proceedings, Judge Rintle and Judge Lane presided over the hearing via video link from London. The upper tribunal ruled in favour of the Home Office and released their decision via a written judgment on October 14, 2019. The upper tribunal concerned itself primarily with parliamentary sovereignty and the dualist nature of the UK's legal system. The Home Office argument consisted of 2 main points. Firstly, that Article 1.6 relates to identity and not citizenship, despite the explicit language of the provision. And secondly, even if it were to relate to citizenship, that provision does not exist in domestic UK law, and therefore under the UK's dualist system cannot be relied upon. The upper tribunal agreed with this view. The submissions by the Home Office were remarkable to both the Good Friday Agreement and international law, contending that the courts of the United Kingdom do not have the power to force the British government to uphold its commitments under international law. In written submission, a distinction between the identity and citizenship entitlements in Article 1.6, stating that the birthright provisions of the British-Irish Agreement allow for the choice of identity, which is not the same as a right to choose citizenship in law. And I always find this argument to be quite entertaining, because how do you put a right to identify or feel a certain way into an international treaty? In addition to this, the department claimed that the absence of the birthright provisions from the Northern Ireland Act 1998 indicated that the provision was not intended to ever have legal scope in terms of citizenship. This is the first time that such an interpretation had ever been put forward by a government department or body since the 1998 agreement. The Northern Ireland Office refers to both the Belfast Good Friday Agreement and the Northern Ireland Act 1998 as forming the basis of a constitutional framework for Northern Ireland. Counsel on behalf of the Home Office argued that the dualist tradition of the UK's legal system has the consequences that an international treaty with domestic courts. However, under Article 27 of the Vienna Convention, a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty, therefore not incorporating provisions of a treaty into British domestic law if they are not already provided for obligations under international law, as many of us will already know. Under the UK's international obligations, a failure to give domestic legal effect to a provision of a treaty does not absolve the government of its obligations. It remains an important principle of public policy to obey an instrument binding under international law, and as such, we believe that the British Nationality Act 1981 should have been read in a way to conform with the international law obligations of the British-Irish Agreement. Our counsel argued for a generous and purposeful approach wherein the constitutional nature of the Good Friday Agreement could be applied. We did, however, achieve a significant concession earlier this year, partly due to mounting political pressure with cross-party support and intervention from the Irish government. The British government committed to changing domestic UK immigration law to align with both the letter and the spirit of the Good Friday Agreement, and stated that these changes would be available to the family members of all the people of Northern Ireland, no matter whether they hold British citizenship or Irish citizenship, or both. This commitment was brought forward in domestic UK legislation 2 weeks before her case was meant to be heard before the Court of Appeal. The changes took effect from August 24th, allowing the family members of the people of Northern Ireland to apply to the EU settlement scheme. Previously, the family members of Northern Ireland-born citizens were unable to apply. The changes amended Appendix EU and added the people of Northern Ireland to the definition of an EEA national. Notably, the definition was replicated, although the negative, many people have discovered they are perhaps an irrelevant person of Northern Ireland, because to be considered a relevant person of Northern Ireland, you must have been born in Northern Ireland to either a British parent or a settled parent or an Irish parent. And there are lots of people that actually fall outside the remit and unfortunately have been calling themselves irrelevant people of Northern Ireland. So I feel kind of guilty about that term. These changes represented a significant climb down in the Home Office position in her case and set a precedent for recognition of the birthright provision. They also placed the people of Northern Ireland in an advantageous position, particularly those who identify as British, who have gained more favourable, albeit temporary, family reunion rights. But there remain significant legislative gaps that need to be addressed to provide for equality of citizenship in Northern Ireland. The Joint Committee of the Northern Ireland Human Rights Commission and the Irish Human Rights and Equality Commission released a report by eminent barrister Alison Harvey on how the birthright provisions of the Good Friday Agreement can be implemented into domestic UK citizenship law, and I highly recommend that report. There are clear parallels between the government's argument in her case and those put forward by the Attorney General in relation to this plan to override parts of the Northern Ireland Protocol. Both defences concern themselves primarily with the supremacy of Parliament and cite the recent case of Gina Miller, who challenged the UK in the courts over various technical moves in relation to Brexit as justification for breaching the UK's obligations under international treaties. Neither holds up logically or legally. Had her case proceeded to the Court of Appeal, this particular argument would have been tested. The difference between her case and the withdrawal agreement is that we were dealing with an unimplemented and unincorporated provision of a treaty in UK law, which is why, in my view, the British government is seeking to override the agreement with further domestic legislation so as to apply this illogical argument. Additionally, as Colm has already laid out, the government has brought forward further amendments to Clause 45 that in part will expressly diminish the incorporation of the ECHR in Northern Ireland law. Any regression of the incorporation of the ECHR in Northern Ireland will undermine the UK's commitments to the Good Friday Agreement. Brexit will, in general, create real difficulties in adhering to the parity of esteem principle of the Good Friday Agreement, even with the Northern Ireland Protocol. The UK's exit from the EU complicates questions around citizenship, identity, and immigration, with British and Irish citizens holding a different set of rights. This is despite the temporary change to the immigration rules that now treats both British and Irish citizens born in Northern Ireland as EU citizens. There remains a significant implementation gap in giving domestic legal effect to the citizenship entitlements of the Good Friday Agreement, as well as a host of outstanding Brexit-related issues that will have a detrimental impact on the everyday life of people living on the island of Ireland. So to close, my own lived experience of being in court with the Home Office and the government for 5 years tells me that the Good Friday Agreement is greatly at risk from a hard right Brexit agenda, one that, of course, the people of Northern Ireland, or the people of the island of Ireland full stop, did not vote for. Thank you.
Thank you, Emma, and thank you very much for joining us despite your local connection problems. And thank you for that really helpful, as you say, personal experience of litigating the Good Friday Agreement and your concerns about its ongoing implementation. I think we're now going to hear from Caoilfhionn Gallagher to wrap up our presentation from each of the panel members, and then, of course, we'll take some questions. So do feel free, if there's anything you'd like to ask, to put it in the chat function, and we'll deal with it after Caoilfhionn. But over to you now, Caoilfhionn.
Thanks very much, Gráinne. I feel it's appropriate that we've had all of these technical difficulties given the dog's dinner that we're speaking about this evening. And I just wanted to start by saying thank you so much to LILA for hosting this. There have obviously been many concerns about the government's frank acceptance that its policy is to breach international law in that phrase in a specific and limited way. And many of you will have seen that Twitter went wild after that phrase. I particularly like Jolyon Maugham's "My client only broke the law in a specific and limited way" is amongst the rarer pleas advanced by counsel in written or oral submissions tweet. But there were some other really good ones. Steve Pears said, "Luke, the Death Star only destroyed planets in a very specific and limited way." Another one I liked. And Alan White, "I fought the law in a very specific and limited way, and the law won." You can see what I'm doing when doing a very heavy case, looking at Twitter late at night. There have been some superb and nuanced discussions and quickfire papers and blogs produced about the ramifications of this for the UK's place in the world, ramifications for the Brexit negotiations, and the constitutional ramifications. For example, the International Bar Association event last night, which was superb, and there's an event coming up in a number of weeks with Baroness Hale. But I'm particularly pleased that LILA has arranged this, because I do think there's a particular perspective for us as Irish lawyers in the UK. And in recent years, I feel many of us as Irish lawyers in the UK have been working overtime, really, on issues on which having an Irish perspective, but being in the UK is particularly helpful. So, for example, on the issue of abortion rights in Northern Ireland, the ramifications for the Good Friday Agreement of proposals to repeal the Human Rights Act, and on Brexit. And what many of us have been trying to do is to assist with what is often a blind spot for policymakers and decision makers here in London, and remind them of the importance of Northern Irish issues. And you'll all recall, and I've spoken on this and written on this over the last number of years, that the Good Friday Agreement and the ramifications of Brexit for the Northern Irish peace process were treated as if this was an unpredictable late problem, when in fact many of us, including many of you who were on this call today, were raising these concerns right from the outset. So I'm very pleased that this has been arranged, and massive thanks to Gráinne for doing it. I think it's particularly important in light of the suggestion that it's for your own good, the argument that Emma just mentioned, describing it as all but sloganeering. And that's very important. For those of you who don't know about that, after the publication of the UK Internal Market Bill, when there was a backlash from the opposition and indeed from some Tory MPs, and following an immediate angry response from the Irish government and from the EU, Boris Johnson then attempted to argue that the proposed legislation was actually designed to protect the Northern Irish peace process and the Good Friday Agreement, which was quite something. And of course, this piece of legislation risks having quite the opposite effect. But I do think it's important we're having this discussion today, because many of the concerns that have been raised in recent weeks have been on the wider issues about the rule of law only, and not about the Northern Irish impact and indeed the Irish impact. So I think it's important we keep that perspective. I have a shopping list of concerns which I thought I'd run through in the minutes that I've got before we open it up to discussion. And I see from the comments that it looks as if some of these are shared. So there are 6 specific concerns which I wanted to flag at this stage. The first and most obvious one is what this means for how Britain will deal with the withdrawal agreement. And as has so often happened to me on the issue of Brexit, being an Irish woman living in London, I find that Simon Coveney speaks for me. When I heard Simon Coveney's words to the Dáil and reported in the 24 hours after the news initially emerged about the plan to breach international law in a specific and limited way, they certainly chimed with many of my immediate concerns. His immediate comments were that what had been said exacerbated his concerns about how Britain would deal with the withdrawal agreement. So this wasn't a new issue, it exacerbated existing concerns. And he said, whilst we still await publication of the legislation, because of course, remember, the running order was we heard about the breach before we actually got the detail. Whilst we still await publication of the legislation, he said, earlier this week, we raised the media reports and briefings on the issue with the UK through diplomatic and official channels to express our concerns. However, rather than being reassured, my concerns have been exacerbated by the additional comments deliberately made in the House of Commons today, openly committing the UK government to legislate to break international law in relation to the withdrawal agreement. And he was reported as saying that he'd asked the Irish ambassador in London to raise the issue directly with the UK government. And he also said, clearly, any unilateral departure from the terms of the withdrawal agreement would be a matter of considerable concern and a very serious step, and would seriously erode and damage political trust, not only in the Brexit negotiations, but also within Northern Ireland at a time of real sensitivity. And that's critical. And something which we might want to talk about in the discussion is the specific ways in which the UK government says it's prepared to break the law and what the ramifications will then be within Northern Ireland. Second on my list of 6 concerns is that this move undermines the UK's ability to negotiate post-Brexit at a time when the UK will have to be negotiating a very large number of treaties. And those of you who did join the IBA event last night will have heard Philippe Sands make this point very powerfully. And if you haven't heard it, I urge you to look at Jonathan Cooper and others on Twitter who summarized key points from that event. But it means that in a situation where the ability to negotiate treaties is primarily based on trust, the UK has fundamentally undermined its trust stock. And it makes it very difficult. You could see immediately with the comments from Nancy Pelosi and others around the world expressing concerns, and even the more cautious words from Mick Mulvaney, show that actually the government has created a fundamental problem for itself on the international stage. And critically, these are not unforeseen issues which have arisen. These are predictable issues. Indeed, they were predicted in the agreement, and they were predicted in the treaty signed less than a year ago and described by this same Prime Minister as oven ready. My cooking's pretty bad, but I think his definition of oven ready obviously leaves quite a lot to be desired. The third issue then, which relates very closely to the second one, is that it fundamentally undermines the UK's position in negotiating treaties far more generally, entirely outside Brexit. And as one commentator on the Financial Times put it, this is a message that has been sent about Britain's national character and identity and how it will conduct itself outside of the EU. Respect for the rule of law is the vital line of separation between democracy and authoritarianism. Britain has been a prolific signer of treaties. The Foreign Office counts more than 13,000 since the 1830s. Each one has carried a kite mark testifying to the unshakable commitment of the rule of law. Yet the sign Mr. Johnson now proposes to hoist over the cliffs of Dover might as well read, "Welcome to Britain, a nation no longer to be trusted." Fourth, and closely related, is there are ramifications for Britain as a place to do business. It sends a message not only in relation to the UK's ability to negotiate treaties, it also sends a message which is destabilizing in relation to Britain as a place to do business. Fifth, and this was mentioned a little at the time, but I haven't heard it mentioned so much in recent days, and it's important, is it has resulted in a loss of key civil servants and officials at a critical time, including, for example, Sir Jonathan Jones, who resigned as the Treasury Solicitor, Permanent Secretary to the Government Legal Department, reportedly after a dispute with Downing Street over plans to undermine the withdrawal agreement. The UK government's law officer for Scotland, Lord Keane, offering his resignation to the Prime Minister on the basis that it's increasingly difficult to reconcile government plans to override the Brexit withdrawal agreement with a planned new law. So at a time when Brexit has already put tremendous strain on the mechanics of government and the mechanics of the civil service, you've yet another problem with the loss of key individuals at this critical time. And then sixthly, and for me, this is one of the most important issues, this drives a coach and horses through the UK's ability to hold other governments to account. The UK has a long and proud tradition of upholding international law, advocating for the primacy of the rule of law. And this is a fundamental departure from that tradition on an issue which is incredibly high profile, and that has the most serious ramifications for the UK's international reputation. Just to give you a practical example, this week I've been working on a number of cases which raise concerns about other countries' compliance with the rule of law, concerning the government of the Philippines, the government of South Sudan, the government of Egypt. And individuals who I'm speaking to on all of those cases make reference to the UK's standing on rule of law issues. It's very hard for us to now say with a straight face that these are violations, these governments are violating the rule of law when you're speaking as a barrister working from the Bar of England and Wales, where the leader of our bar is the Attorney General, who is supporting this breach of international law. And rather similarly to the problems that arose in relation to Donald Trump's attack on journalism, describing journalists as enemies of the people, which then made it very difficult for the US to negotiate on freedom of expression issues, because of course you then have Duterte and other authoritarian governments essentially adopting a line on press freedom, which is straight from the Trump playbook. Similarly here, the governments which we're working with every day on these cases are now able to say that breach of international law in a specific and limited way is something which the UK says is okay. And I do need to commend my colleague and co-counsel on the Maria Ressa case, Amal, for withdrawing from her role as the United Kingdom's Special Envoy on Media Freedom in an incredibly powerful letter. And if you haven't seen it, you should read it, setting out why she was dismayed to learn that the government intends to pass legislation which would, by the government's own admission, break international law. And she described it as lamentable for the UK to be speaking of its intention to violate an international treaty signed by the Prime Minister less than a year ago, considering it made her role untenable as a Special Envoy on Media Freedom. Similar position was taken by the Special Envoy on Freedom of Religion and Belief, also saying his role had become untenable. And today, astonishingly, I've emerged from my long Zoom hearing to see that the government has been accused of, and I quote, beyond laughable hypocrisy for running a campaign extolling the virtues of democracy and the rule of law to other countries after appearing to repeatedly undermine them itself. And if you haven't seen this, go on Twitter and take a look. It's the hashtag #BeHeard campaign launched by the Foreign Office, names independent judges free to uphold the law as a key element of democracy, alongside protecting the rights of minorities and allowing the press to challenge those in power and to shine a light where it's needed most. But unsurprisingly, ministers are being accused of saying one thing whilst doing another in launching that campaign, given that they have openly admitted that they're planning to break international law with this new legislation. And that decision fundamentally undermines their ability to launch important campaigns like the Be Heard campaign. Now, I may sound in making these comments like an activist lawyer, and indeed much of my work is activist law work, but it's particularly galling to have this happening in relation to international law only weeks after those of us who do our jobs as human rights lawyers or as immigration lawyers or public lawyers acting for claimants, acting for little Davids against big Goliaths all the time and doing our job properly and complying with our professional obligations. When we've been criticised implicitly and explicitly as if somehow by acting for those individuals and doing any campaigning work, we are not being proper lawyers. It's particularly galling to have the same government now openly accepting that it's going to move away from the rule of law and that it is going to breach international law in a specific and limited way. So I say, London Irish lawyers unite, activist lawyers unite, and we must say that this simply is not good enough and that there are very, very serious concerns and ramifications for this decision, which are not specific and limited, but far more grave and wide. Thank you.
Thank you very much, Caoilfhionn. And I was interested to hear you talk about some of the wider issues, including the reference that you've made to criticisms of the profession, including by the Home Office. And you mentioned this sort of wider picture. And I noticed that Philippe Sands yesterday in the IBA lecture said that there were parallels with what's happening in America in terms of a desire, an actual strategy to move away from multilateralism and away from an international rules-based system. One of the issues that I think is interesting is whether or not this is just a once-off political act or a symptom of a much larger political ideology or strategy. Something for you or for Colm to come in on.
I'm not sure if, I'll let Colm.
Yes, thanks, Caoilfhionn. Well, I think this is exactly what's happening. I think it's a deliberate choice of a confrontational, rule-breaking strategy as part of negotiations with the EU, but as also part of a more. But I've heard a certain degree of speculation that the government is actually might actually be quite happy to see legal challenges brought to the ouster clause dimension of clause 45. So if someone like Caoilfhionn ends up on her feet before the up in front of the High Court challenging some dimension to clause 45 and how it might apply, for example, to a state aid regulation cutting across the protocol in the event of a no deal, that the government might actively welcome this as adding to its crusade against activist judges, activist lawyers, cosmopolitan, foreign elite, North London types. Now there might be speculation behind that, but I actually think there's a lot going on there. I think that's exactly what's happening. It's a deliberate embrace of a confrontational strategy.
Yeah, so I agree with Colm in relation to what it is, and I think obviously you've got the one-off saber-rattling aggressive approach. I think it's indicative of a wider strategy. I mean, this doesn't come completely out of the blue. If you look at other attacks, like those attacks, for example, on activist lawyers, or and I hesitate to say this, it's opening up quite a can of worms, but the current approach in relation to reviewing judicial review and the very role of judicial review. So this is not an aberration. This is part of a playbook, which I think is deeply concerning. And I think Colm's point about in some ways the government welcoming this being in the courts is probably right, because of course there's also the picture, which is the attempt here to paint judges as enemies of the people. And you have the disgraceful way in which the Miller cases were presented as if somehow that was judges against the people, when of course when you read those cases, they're in many ways deeply conservative, and they involve protecting and upholding the supremacy of Parliament and the rights of Parliament against the executive. But it would be quite different here if there was to be a challenge to the bill or a challenge to the act in the domestic courts. Given the parliamentary arithmetic, if it goes through, it would then be a challenge to a piece of primary legislation which Parliament had supported. So quite different to the prior Brexit legislation. That's a rather brief answer, Gráinne, to a very big question.
No, great answers. Thank you both very much. And tying in on the same theme, I have had a couple of questions sent to me privately, one from Gavin, Irvin and Colm. I might start with you on this and then come to Caoilfhionn and Emma if they'd like. He says Brexit requires significant new law to replace old, soon-to-be defunct law. In the world of financial sanctions, last week we saw UK secondary legislation amending UK secondary legislation that amended UK primary legislation. So does all of the difficulties that we've seen with overuse of executive power, overuse of delegated legislation, constitute a broader UK constitutional crisis and more than simply what we're seeing in relation to this one piece of legislation?
Yes, I mean, we've obviously emphasised the Good Friday Agreement because it's the London Irish Lawyers Association. It's what I think is being slightly overlooked in all of this in the UK is that we are talking about a quite profound violation of a lot of the unwritten norms of the UK Constitution. Of the unwritten UK Constitution, Rules 45 turning into a sweeping part of the stabilisation of the devolution agreement, of the devolution. And also, we have a massive, if you take the provisions of clause 43 relating to state aid, and you see today, I've seen some discussion that a draft regulation has been laid before Parliament which would effectively ministerial regulation, which would disapply existing EU state aid law from applying after the transition period ends. We're going to be in a situation where effectively the entire state aid regime is going to be controlled by ministerial regulation. Now, for those of you working in the area, that's fairly massive, and it's fairly unprecedented in any other constitutional democracy that I can think of. So all of this is part of a wider pulling in of power to the executive, and in particular to the central executive in Westminster.
Thanks, Colm. Keelan, I don't know if you wanted to come in on anything further to what Colm's just said.
Yeah, so as ever, it's always nice to follow Colm. I can just say I agree, or I follow, as we get to say in the Supreme Court. Just a quick point on that state aid issue. Some of the commentary on the state aid issue has been pretty interesting, I think, and worth taking a look at, because under Article 10 in the protocol, EU state aid law applies to measures which affect trade between Northern Ireland and the European Union. But it appears the UK government, or some parts of the UK government, only realised belatedly that could include businesses that operate UK-wide, who would then also be subject to EU rules. So the decision to empower ministers to apply Article 10 of the protocol according to their own interpretation has been read in many quarters as being motivated more by a desire to advance the UK's own political interests. It's the UK's insistence on having complete autonomy over any new subsidy being a stumbling block in future relationship talks with the EU, rather than to protect Northern Ireland trade. So that also has wider ramifications, I think, and wider reputational ramifications, given that that's the read in relation to what motivates it. I'm not sure if Emma has anything to add to that. I'm conscious Colm and I have been speaking quite a lot.
I think that all I can really add to both of those contributions is I agree. Yes to all that both of you said, 100%. I can't add more to that.
Well, Emma, I wonder if you wanted to say a few words, because obviously the broader constitutional crisis that's been referred to and where that leaves Northern Ireland. I'm thinking in particular the campaign which for a Bill of Rights in Northern Ireland, which seems largely to have been on the back burner for some years now. Is that something that you still think would be useful, given everything that's happening?
I mean, consider if you look at the remit of a Bill of Rights for Northern Ireland, if we had have actually got a Bill of Rights as laid out by the recommendations in 2008, then it's hard to see how Brexit would ever have worked in Northern Ireland, because it would not have been compatible with the Bill of Rights and the Good Friday Agreement in general. So, of course, here in Northern Ireland, in civic society and across political groups and academia and the legal profession, we're all still fighting for a Bill of Rights and working to try and get that across the line. But at the moment, it's on a very long, large list of issues that are becoming ever more complicated, with the fact that the Northern Ireland Protocol is not being properly implemented, it's not being adhered to, it's now being undermined. Combine that with big concerns around the integrity, not just of the Good Friday Agreement, but the integrity of the Common Travel Area, and how that's going to really operate whenever it's going to be restricted to just British and Irish citizens. So, of course, we've got big questions over, well, what about the Polish child that goes to school and cross-border education? What about families traveling up from Dublin? So there's lots of concerns around the Common Travel Area and how that's really going to operate in the island of Ireland. So we've got a long list of issues that are extremely complicated, and really stability that we have here is on the basis of complex legislation, and having that relationship with the EU and the protection of EU law is what has given us the stability we've had for the last 2 decades, and we're about to lose all of that. And then we have, of course, this bill which is drawing in power to Westminster, which is making us even more concerned, because instead of gaining more control over our rights and entitlements in Northern Ireland, we seem to be losing them. So it's a very big uphill battle for all of us, but thankfully we're all working together to try and fight against it.
Thank you, Emma. And I think just one final question. We were due to finish at 1:15, so this might be the last one for anybody on the panel to respond to. It's from David Hardstaff. Aside from the key international ramifications of the bill, which has been, I think, discussed by everyone, what do the speakers consider the longer term potential damage to the rule of law domestically, particularly given the growing lack of trust in the government generally? And then the example is given of the handling of COVID-19.
I can go with that, but again, you've heard a lot from me. So, but very briefly, if you want a template, Clause 425 is a clear template for performing a highly effective ouster clause operation that isn't a formal ouster clause, but effectively amounts to a de facto ouster clause, material regulations from substantive legal challenge. And it's a clear template that you could take up and apply in different contexts. So if clause 45 goes into the statute books, we're all going to get used to, I suspect, seeing it occur in different formats, different modes. Very similar statutory language may start appearing in different contexts after different contexts.
I'll go after Emma if Emma wants to say anything.
Okay. Well, I think for me, outside of that concern is going to be the concern around accountability. You know, how can we hold the government to account whenever they're undermining the rule of law? So for me, that's a huge concern that we have going forward. And the concern, of course, being that as citizens, what protections do we have whenever they're starting to undermine judicial review and starting to pull away and pull back on those rights? So for me, that would be a primary concern.
Yeah, so I obviously agree with what Colm and Emma have said. And I was looking back at the words of the former Justice Minister, Lord Foulkes, very recently in 2015. It's only 5 years ago, saying ministers would not breach international law. And look how far we've come in 5 years. It's so concerning when you look at those words now as reflecting government policy at the time, and you look at what's happening now. And there have been a series of other examples, as well as some of the points which Colm and Emma have made, which have real cause for concern. If you look at very different contexts, but you look at, for example, at the welfare cases, the benefit cap cases, the government has been quite happy to say, we recognise that this is a breach of the UN Convention on the Rights of the Child, but it doesn't breach domestic law, putting clear blue water between international standards and domestic law. So I see it also as part of a very worrying trend. As a human rights lawyer, I'm finding that repeatedly there's pushback in relation to how international law applies in the domestic courts. And I think we need to keep a very close eye on that issue. And that's something we'll need to do going forward, because I do think it's part of that broader pattern of sidelining and undermining international law standards. And of course, there are things we can do in the international arena about that. But I do think government policy at the moment is to make it increasingly difficult for us to get traction on those issues within the domestic arena.
Well, thank you, all of you, for those contributions. And I think that's probably as good a point to leave it on as we're going to get this evening. And I hope that you'll agree with me that that's been a really interesting tour de force, both in relation to this bill, in terms of what it entails, why it is of concern, and the likely ramifications of it, as well as some thoughts and analysis on the wider difficulties, growing constitutional problems and worrying trends with relation to the rule of law more generally. And also, and perhaps of most concern for us, not only as lawyers, but as Irish lawyers, that there are, and I think Emma reminds us very well, the use of the Good Friday Agreement as an apparent justification for this proposed breach of international law is of concern. And there will obviously remain challenges and risks to that agreement in the months and years ahead. So I hope you'll all join with me in saying thank you to our three speakers. I really appreciate you giving up your time to join us this evening. We've got some claps on the Zoom, which is always welcome. And thank you also to all of you for attending. We would obviously normally very much like to be doing this in person and to be staying for a drink and saying hello to you all, but soon we hope. And in the meantime, it's great that we can still have these discussions. And I agree completely with Caoilfhionn that it's important that we keep having them, particularly because we do have a unique perspective on the challenges that we're all currently facing. So thank you finally also to Amy for managing Zoom this evening. And one final thank you to all our speakers. And hopefully we'll see you all in person at our next event soon. Thank you all very much.